There is this very specific visceral sinking feeling that happens the exact moment you open a brand new bag of chips.
Oh, absolutely.
Right. Like you're anticipating that salty, savory aroma, and instead you get hit with this foul, stale, almost chemical scent of rancid oil.
It is a profound psychological letdown. I mean, you've anticipated a reward.
Right, go ahead.
You've surrendered your capital for it, and the resulting product is not just disappointing, it's practically inedible. It's basically a breach of an unwritten social contract.
A breach of contract, exactly. Or, consider something with much higher stakes.
Like what?
Like, you take your vehicle to the dealership, and it's undeniably under a 2-year manufacturer warranty.
Okay, yep.
You drop it off, the mechanic resolves the issue, hands you the keys, and then, without batting an eye, slides this printed invoice across the counter for a $200 quote-unquote diagnostic and service fee.
Oh, man. That creates a fascinating internal conflict.
It really does. Because you recognize immediately that the fee violates the spirit of the warranty.
Right. It feels less like a valid commercial transaction and far more like a localized shakedown.
That is the perfect word for it, a shakedown. But the structural power dynamics in that room are overwhelmingly against you.
Oh, completely. The paperwork is dense. The service manager is literally standing between you and your vehicle.
Yeah, and the sheer administrative friction of fighting it usually results in you simply handing over your credit card.
Which happens millions of times a day.
It does, and it's in those exact moments, standing at the service counter or looking down into a bag of ruined food, that the illusion of being an empowered participant in the free market just, shatters.
You realize how incredibly small and isolated you are.
Exactly. Isolated within the grand churning machinery of modern commerce.
Mm-hmm.
But the underlying reality, and really the entire reason we are doing this deep dive today, is that you are not actually alone in that transaction.
Not at all.
You are enveloped in this invisible, highly evolved legal architecture. So today, we are exploring the vast historical and legal evolution of consumer protection.
It's a massive topic.
It is. We're looking at a stack of sources today that trace an incredible journey. In fact, it looks exactly like the syllabus for Unit 2 of an Osmania University law course.
It really does. It covers everything from UN guidelines to some very specific Indian statutes.
Okay, let's unpack this. What is the actual mission here?
Well, we are essentially charting the legal history of the balance of power. I mean, we all participate in the market daily.
Right. We buy, we consume, we subscribe to things.
We agree to terms of service. But the vast majority of us operate with a fundamental misunderstanding of the legal armor we are entitled to wear.
So true.
The objective today isn't just to list laws, it's to map out how we move from a marketplace where the individual was essentially prey to a system characterized by global human rights standards, complex national statutes, and ultimately sweeping modern legislation designed for the digital age.
Because to understand the strength of the armor, we really have to start by analyzing the specific weapons that have historically been deployed against the buyer.
We do.
Let's look at what the sources define as the core problem. Basically, the structural helplessness of the consumer.
Yeah, the market isn't just neutral ground. It inherently tends toward exploitation unless it's actively constrained.
If we look at the historical data and the market analyses provided, the variety of traps is just, staggering.
It is, and we are not talking about the occasional manufacturing defect, where a machine on an assembly line misses a bolt.
Right.
We are analyzing systemic, deeply ingrained malpractices that function as secondary revenue streams for bad actors.
And the sources catalog practices that sound almost Victorian, yet they just persist continuously.
Like adulteration.
Yes. Take adulteration.
Yeah.
You buy what is labeled as pure turmeric powder, relying on visual cues.
Right. Only to discover it has been systematically cut with cheap synthetic yellow coloring.
Which is terrifying.
Yeah.
Or the proliferation of spurious goods.
Yeah, you purchase a reputable pharmaceutical brand assuming you are buying safety.
And it's a biochemically inert or even dangerous counterfeit.
Exactly. And we have to look at the macroeconomic manipulations as well. The texts highlight things like hoarding and black marketing.
Which aren't just annoyances.
No, they are deliberate strategies to artificially constrict supply chains, creating localized scarcity to drive up prices.
It's market manipulation at its most predatory. And then you have the historical reliance on false weights and measures.
Oh, the false weights issue is fascinating because of its psychological subtlety.
Yes, because the manufacturer prints 100 grams in bold, reassuring typography on a packet of noodles, knowing with absolute certainty the contents weigh 80 grams.
And if they do that to 1 million units, the profit margin is astronomical.
It's essentially grand larceny executed through 1 million microscopic cuts. And it relies entirely on the fact that no individual consumer is going to, calibrate a kitchen scale to check their instant noodles.
Right. Nobody has the time for that. Add in misleading advertisements.
Oh, like promising a dietary supplement will alter your fundamental biology.
Exactly. Or cure an underlying disease when it does absolutely nothing. When you aggregate all those practices, the landscape looks entirely hostile.
Adulteration, systemic short weighting, artificial scarcity, engineered deception.
You begin to see the marketplace not as a space of mutual exchange, but as a heavily fortified corporate entity extracting value from an isolated individual.
Because the seller possesses complex supply chains, sophisticated marketing psychology departments, and aggressive legal counsel.
And what does the buyer possess? A few dollars and a fundamental need for the product.
It's totally David versus Goliath. Now, I understand the instinct to view this purely as an asymmetric war, the evil, monolithic corporation extracting blood from the innocent populace.
It's an easy narrative.
It is, but I think we need to look closer at the behavioral economics highlighted in our sources, because the texts do not let the consumer completely off the hook.
No, they don't.
Is it really just about evil corporations, or is it also about consumer apathy? They point directly to a phenomenon defined in the documents, literally as a lethargic attitude.
What's fascinating here is that this lethargy is actually a mathematically rational response to friction.
How so?
Well, think about it. If you purchase a contaminated food product for $3, the traditional avenues of redress require you to absorb massive transactional costs.
Right, you need to draft a legal complaint, navigate a labyrinthine civil court system.
Potentially hire representation and sacrifice days of your time. The corporation relies on this calculus.
They know the friction of fighting back exponentially exceeds the financial loss of the defective product.
Exactly. So the exploitation isn't necessarily a failure of the market. It's a feature of information and economic asymmetry.
Because the corporation holds the proprietary data on the chemical breakdown of the product, and the consumer operates on blind trust.
And educational imbalance plays a huge part, too. The corporation spent hundreds of hours drafting a 20-page terms of service agreement.
And the consumer spends 0 seconds reading it. They simply click agree to access the utility of the software.
Right. This dynamic dictates that an individual buyer cannot possibly fight a manufacturer without heavy institutional intervention.
Which brings us to the philosophical underpinning of why the state intervenes at all. Because for a long time, the prevailing legal doctrine was caveat emptor, buyer beware.
The market is a jungle, and if you buy a bad horse, that is your failure of inspection.
But the sources outline why that philosophy is ultimately self-destructive to capitalism itself. There is this concept deeply embedded in the evolution of these laws called the principle of trusteeship.
The principle of trusteeship is fascinating because it sounds almost counterintuitive to raw capitalism.
It really does. It suggests that businesses do not exist in a vacuum, generating wealth purely for their own internal stakeholders.
Right. Instead, because they derive their operational license and their revenue from the broader society, they hold their wealth and their power in trust for that society.
Which frames fraud not just as a contract dispute, but as violation of a social trust.
And the macroeconomic reality is that a market saturated with unpunished fraud eventually implodes.
Yeah, if the consumer base reaches a threshold where they fundamentally cannot trust the purity of the agricultural produce,
or the safety specifications of a vehicle, or the efficacy of a pharmaceutical,
the velocity of money slows down. Commerce just paralyzes.
Therefore, protecting consumers is actually good for business survival and growth. It's not an act of state charity. It is the essential maintenance required to safeguard the structural integrity of the market.
It provides the baseline social justice required for a capitalist economy to actually function. And, that realization that the isolated consumer was vastly outgunned and that market integrity was failing, it wasn't isolated to any one country.
No, it was a global crisis of the late 20th century.
Which leads us to a massive paradigm shift on the world stage. We have to look at the United Nations General Assembly Resolution 39248.
Adopted on April 9th, 1985.
Yes. Why did the UN suddenly care about how we buy refrigerators or medicine?
The 1985 UN guidelines represent a watershed moment. We typically associate the United Nations with geopolitical stabilization or human rights tribunals.
Not grocery shopping.
Exactly. The fact that the General Assembly focused its apparatus on product safety is incredibly telling.
If you look at the geopolitical context of the 1980s, globalization was accelerating at an unprecedented rate.
Multinational corporations headquartered in the West were aggressively expanding their supply chains into developing nations.
And those developing nations frequently lacked the sophisticated regulatory frameworks required to manage massive multinational entities.
It was an environment ripe for regulatory arbitrage. A corporation could manufacture a product that was deemed too hazardous to sell in North America or Europe
And simply dump it into a developing market where the legal friction was negligible.
The UN intervened because they recognized that unmitigated economic exploitation is a direct barrier to human development.
The text outlines the specific objectives of that 1985 resolution. The primary goal was to assist developing countries in achieving and maintaining adequate protection for their populations.
They wanted to curb abusive business practices at both national and international levels.
And encourage ethical conduct for entities engaged in production and distribution. They essentially handed down a blueprint, right?
Yes, telling member nations to build formal, inexpensive, and accessible redress procedures.
And what is particularly profound about the UN guidelines is their explicit recognition of the needs of low-income consumers specifically.
Historically, consumer protection was often viewed as a luxury for the affluent, ensuring the tailor delivered the bespoke suit as promised.
Or the jeweler didn't substitute stones.
The UN shifted that perspective entirely. They recognized that for a low-income consumer living near the poverty line, being cheated on the weight of essential grains or purchasing a toxic cooking oil is not an inconvenience.
It is an existential threat.
It elevated consumer protection from a matter of commercial contract law to a fundamental global human right.
By urging governments to establish legal architectures that were expeditious and inextensive, the UN was directly attacking that lethargy calculus we discussed earlier.
They were demanding that states lower the friction of seeking justice.
So the UN lays down the blueprint. How did India respond? When we look at the historical sources, it wasn't as if the country was a lawless void prior to 1985.
Far from it.
There was a dense, almost impenetrable thicket of legislation already on the books. This is what we can term India's patchwork era.
Patchwork is a highly accurate descriptor. It was a labyrinthine system of highly specific, fragmented statutes.
The legislative intent was present, but the execution was scattered across dozens of different domains. Let's examine this architecture from the sources.
It's a long list.
It really is. You have the Sale of Goods Act of 1930, the Agricultural Produce Grading and Marking Act from 1937, the Drug Control Act of 1950,
The Prevention of Food Adulteration Act of 1954 aimed at that chemical tampering we discussed.
the Essential Commodities Act of 1955, designed to prevent hoarding, the Standards of Weights and Measures Act of 1956, the MRTP Act of 1969, the Trademarks Act, the Drugs and Cosmetics Act.
Eventually culminating in frameworks like the Bureau of Indian Standards Act. On paper, it appears comprehensive.
It does. If a baker sells you contaminated bread, there's a law for that. If a pharmacist sells you a dangerous cosmetic, there is a law for that.
Right.
So this sounds like a lot of law. Why wasn't this enough to protect the listener? Why did consumers still feel completely powerless?
The structural flaw lay not in the coverage of the laws, but in the nature of the legal remedy they provided.
Meaning what exactly?
The critical distinction here is between punitive law and compensatory law. Almost all of those early enactments were deeply rooted in criminal jurisprudence. They were primarily punitive.
Which means their entire mechanism was designed to punish the bad actor rather than heal the victim.
Precisely. Let's trace the mechanics of how this actually worked. Suppose a shopkeeper is systematically using rigged scales, violating the Standards of Weights and Measures Act. Okay. The individual consumer who was cheated out of 20% of their rice cannot simply sue the shopkeeper under this act.
They can't.
No. Instead, a government inspector, a state agent, must discover the violation, confiscate the scales, and file a criminal complaint on behalf of the state.
Wow. And if the court finds the shopkeeper guilty,
The state imposes a fine, which goes directly into the government treasury, or the shopkeeper goes to jail.
but wait, what about the consumer who paid full price for an underweighted bag of rice?
The consumer is legally invisible in that resolution. They might be called as a witness for the prosecution, but they receive zero direct relief. They do not get their stolen money back.
They don't get a replacement bag of rice.
Right.
The state extracts its penalty, but the victim is left to absorb the economic loss.
It is a staggering failure of individual justice.
Think of it like this. If an aggressive driver rear-ends your car at a red light and a police officer witnesses it, the officer will write the driver a ticket for reckless driving.
Right.
The driver pays a heavy fine to the city. But that ticket does absolutely nothing to fix your crushed bumper. You still have a broken car and an empty wallet.
That analogy perfectly isolates the failure of the patchwork era. The state was essentially operating a toll booth, where the consumer's injury was just the excuse to charge the corporation a toll.
The victim was completely left out of the economic equation. And the procedural hurdles were equally insurmountable, right?
Oh, completely. You were entirely dependent on an under-resourced, potentially corruptible apparatus of state inspectors to champion your cause through a civil and criminal court system that was notorious for generational backlogs.
But what about the MRTP Act of 1969? Monopolies and restrictive trade practices. That sounds like a powerful tool to prevent massive corporations from crushing the consumer.
The MRTP Act was ambitious, but its focus was macroeconomic. It was designed to prevent the concentration of economic power in the hands of a few giant conglomerates. It wasn't until amendments in 1984 that it gained some utility as a specific consumer protection tool. But even then, it was a blunt, unwieldy instrument. Eventually, the realization that MRTP was insufficient led to its evolution into the Competition Act.
But again, that's a structural market regulation, not a direct consumer redress mechanism.
Exactly.
So, despite this dizzying array of statutes, the individual buyer remained essentially naked in the marketplace. Because slapping the wrists of corporations didn't help the buyer, a new approach was needed.
The system needed to move from a philosophy of state punishment to a philosophy of personal restoration.
Enter the Consumer Protection Act of 1986.
The CPA of 1986 is the foundational bedrock of modern Indian consumer rights. Enacted just a year after the UN guidelines, it represents a complete structural overhaul.
It bypassed the congested traditional courts and created a parallel universe of justice specifically calibrated for the consumer. And the sources note this act was heavily influenced by the 6 consumer rights originally championed by former U.S. President John F. Kennedy.
If we connect this to the bigger picture, we need to dissect these rights, because they represent the exact inverse of the helpless consumer model.
Let's list them out. The first is the right to safety.
This is the legal guarantee of protection against the marketing of goods and services that are hazardous to life and property.
It sounds basic, but its implications for manufacturing are massive. It means the law assumes your microwave will not spontaneously combust.
Or the steering column in your vehicle will not detach at highway speeds. It shifts the burden of rigorous safety testing onto the manufacturer.
Then there's the right to be informed.
This directly attacks the information asymmetry we discussed. The consumer has a codified right to know the quality, quantity, potency, purity, standard, and price of goods.
It is the legal mandate behind expiration dates on dairy products, complex nutritional lists, and the bold printing of the maximum retail price, or MRP.
It strips the seller of the advantage of hidden variables. The third is the right to choose. This guarantees access to a variety of goods and services at competitive prices.
It ensures you aren't forced to pay extortionate rates for a life-saving pharmaceutical simply because a single corporate entity has a chokehold on the supply chain. The fourth right is a massive procedural shift, the right to be heard.
The assurance that consumer interests will receive due consideration at appropriate forums. Before 1986, the consumer was a passive witness. This right hands the microphone directly to the consumer.
Which leads directly to the fifth and most transformative right, the right to redress.
The right to seek legal redressal against unfair trade practices or unscrupulous exploitation. CPA 1986 was revolutionary because it finally provided direct relief.
This is the mechanism that finally fixes the broken car bumper from our analogy. If a corporation wrongs you, the forum possesses the legal authority to force the corporation to refund your money, repair the defect, or replace the item.
Or pay you direct financial compensation for the injury and loss you suffered. The victim is made whole.
And the final right is the right to consumer education. The legislative acknowledgement that a well-crafted law is useless if the populace is ignorant of its existence.
Recognizing that an informed consumer base is the ultimate regulator of a free market.
To truly comprehend the power of this shift toward compensatory justice, the sources provide a brilliant case study. The matter of Vina Khanna versus Ansell Properties, adjudicated in 2007.
We must unpack this case. It perfectly demonstrates how the forums established by the 1986 Act operated on complex economic realities.
Real estate has historically been an arena of profound consumer exploitation.
Heavily. The power dynamics heavily favor the developer, who controls the asset, the construction timeline, and the capital.
In this specific case, the complainant, Vinakana, entered into a formal agreement to purchase a flat from the respondent builder, and the contract contained a highly specific written commitment delivery by June 1st, 1999.
So the parameters are crystal clear. But as is incredibly common, the builder failed to construct the flat by the specified date. They breached the contract.
Faced with this deficiency, the complainant exercised her rights and demanded a refund. Specifically, she asked for the return of her deposited capital with an interest rate of 18% per annum.
The builder predictably refused, forcing her to escalate the matter to the Consumer Commission.
Now here is where the mechanics of true redressal become fascinating. The case eventually reaches the National Commission. They look at the timeline and make a critical economic observation. By the time they are adjudicating this, the case has been trapped in the dispute process for roughly 5 years.
Right. And what happens to the macroeconomic environment of the real estate market over half a decade?
It appreciates exponentially.
The Commission noted a tremendous rise in the market prices of immovable property during those specific intervening years.
This is the crux of the matter. If they applied a simplistic, robotic interpretation of the law, they would just order the builder to return Vinakana's original deposit, maybe with nominal interest.
But the Commission recognized that a simple refund would actually constitute a devastating financial penalty for the consumer. Because of rampant inflation in the housing sector, the capital she deposited in 1999 possessed significantly more purchasing power then than it did 5 years later.
If she simply got her money back, she would be completely priced out of the current market.
Meanwhile, the builder would have effectively enjoyed an interest-free loan of her capital for half a decade, while retaining an asset that had doubled in value.
A basic refund would have rewarded the corporate breach of contract. So the National Commission wields the compensatory power of the 1986 Act.
They ruled that it is the absolute duty of the builder to deliver the flat, and she must be awarded suitable compensation for the delay.
But crucially, they dictate that if physical delivery of the original flat is no longer possible, the compensation provided must be adequate enough to allow the consumer to buy a new flat of the exact same size at the prevailing market rate in that specific locality.
It is a masterclass in restorative justice. They force the massive developer to absorb the cost of market inflation,
ensuring the consumer was mathematically restored to the position she would have been in. It is the absolute embodiment of the right to redress.
And as a quick aside, the historical prevalence of cases exactly like this one is what eventually necessitated the creation of the RERA Act, the Real Estate Regulation and Development Act.
Right, because real estate transactions became so complex, they had to create an entirely separate architectural layer of consumer protection just to force transparency onto developers.
Standardizing the housing market, much like the Food Adulteration Act standardized groceries.
But returning to our timeline, the 1986 Act was brilliant. It built the forums, guaranteed the rights, delivered compensatory justice. The landscape was balanced.
It was a magnificent piece of legislation for the era in which it was drafted. But, well, time did not stop in 1986.
Here's where it gets really interesting. The 1986 law was flawlessly designed for a physical, analog reality. It was great for buying a physical radio at a local shop.
But what happens when you buy a smartphone online from a seller 3 states away?
Exactly. What happens when the fundamental geography of commerce is obliterated?
We entered the era of digital disruption. The subsequent decades witnessed a total metamorphosis: e-commerce, direct selling networks, teleshopping.
I like to use an analogy here. The 1986 Act was like a meticulously drafted, beautifully illustrated paper map of a vast city. For years, it was an incredibly reliable tool.
But then the internet happened.
Right. It was the equivalent of massive, invisible highways being constructed in the sky. If you were a consumer navigating this new terrain using only your 1986 paper map, you were going to drive right off a cliff.
The Indian legal apparatus recognized this growing dissonance. The 1986 Act had developed massive lacunae gaps in the digital era.
The mechanisms of buying and selling had outgrown the vocabulary of the statute.
Think about the legal definition of the word buy. Under a strict interpretation of older laws, some corporate defense attorneys could legitimately argue that a consumer did not legally buy a product if they never set foot in a jurisdiction.
Or never physically interacted with a seller and merely tapped a glass screen to initiate a digital transfer of funds to a drop shipper located in another hemisphere.
The very definition of who qualified as a consumer was under threat, which necessitated a radical legislative update.
Enter the Consumer Protection Act of 2019. It wasn't just an amendment, it was a comprehensive rewiring of the system.
Section 2(7) of the 2019 Act tackles the digital reality head-on. The definition of a consumer had to be explicitly expanded to include online transactions.
The sources show they distinctly outline that buys any goods and hires or avails any services now unequivocally include all online transactions conducted through electronic means,
As well as direct selling, teleshopping, and multi-level marketing. They explicitly codified the existence of the e-consumer. They took away the corporate loophole of saying, well, it happened on the internet, so traditional commerce laws don't apply.
This codification brings us into the era of the modern shield. The Consumer Protection Act of 2019 serves as the GPS system replacing the outdated paper map.
It introduced an array of highly sophisticated legal tools and jurisdictional innovations.
So what exactly are these new GPS tools? Let's analyze the mechanics, starting with territorial jurisdiction.
Territorial jurisdiction dictates the geographical location where a court or commission holds the legal authority to hear a case. Prior to 2019, the general rule of thumb heavily favored the seller.
Meaning you had to file where the seller was located.
Yes. If you wanted to file a complaint, you had to file it in the specific geographic jurisdiction where the opposing party officially conducted their business.
Which, in the age of e-commerce, is a strategic nightmare. Imagine you live in a small town in northern India. You purchase an expensive, defective piece of electronics online from a massive corporation headquartered 2,000 miles away in Bangalore.
Under the old rules, the law essentially stated, you have every right to sue this company, provided you are willing to purchase a plane ticket, travel to Bangalore, hire local counsel, and appear in their local commission.
It weaponized the lethargy calculus. The travel logistics made pursuing justice economically unviable. It was a geographical shield for corporations.
The 2019 Act utterly dismantles this advantage. It radically expands territorial jurisdiction, explicitly enabling the consumer to file a complaint where they live or work.
The strategic implications are incredible. Now, the multinational corporation in Bangalore is legally compelled to dispatch their legal team to your small northern town.
It equalizes the logistical battlefield. But the 2019 Act goes much further. It addresses the concept of unfair contracts, detailed under Section 246.
This is vital because we don't negotiate terms line by line anymore. We are presented with digital adhesion contracts.
Dense 20-page terms of service agreements filled with impenetrable legalese. Click I agree or forfeit access to the service. There is zero negotiation.
The law recognizes these are frequently weaponized. Section 246 defines an unfair contract as one that imposes terms causing a significant change in the rights of the consumer. It protects buyers from excessive security deposits or unilateral termination by sellers.
Right. It allows the commissions to look past the fact that you clicked agree and examine the inherent fairness of the clauses.
So if a software company decides to unilaterally terminate your lifetime access to a digital product just because it suits their new business model, they can't just point to paragraph 47 and say, you clicked agree.
The commission can declare that clause null and void. You are no longer held hostage by completely one-sided agreements.
And speaking of modernizing, the 2019 Act integrates e-filing and formal mediation mechanisms.
The central government established the eDocule portal. It facilitates the complete electronic filing of consumer complaints from anywhere in the country.
And the new Chapter V, provisions for mediation.
Mediation serves as a sophisticated alternative dispute resolution mechanism. Rather than a prolonged litigation process, the Commission can refer suitable cases to a panel of accredited mediators to negotiate an amicable settlement. It saves years of anxiety and judicial resources.
These are powerful upgrades. But there is a specific addition in the 2019 Act, Chapter 6, that the sources highlight as the most muscular enhancement of consumer power in Indian legal history.
Product liability.
Let's dissect this. How does it contrast with the pre-2019 reality?
Previously, if a product contained a manufacturing defect, the primary remedy was replacement or a refund, which is fine if a television won't turn on.
But what if a poorly manufactured lithium-ion battery in a smartphone detonates next to someone's face?
Exactly. Or a compromised pressure cooker explodes. Under the old regime, securing compensation for the consequential damages medical bills, physical trauma was a highly complex battle relying on general tort law. The burden of proving negligence was incredibly difficult.
The 2019 Act changes the rules of engagement. Section 83 explicitly establishes a product liability action. It states that a complainant can bring an action against a product manufacturer, a product service provider, and a product seller.
Notice the specific phrasing. The law casts a strategically wide net over the entire supply chain.
Let's break down how this liability is distributed. Section 84 outlines the liability of the manufacturer. They are liable if the product contains a manufacturing defect, is defective in design, or, and this is critical, fails to contain adequate instructions or warnings.
Moving down the chain, Section 85 targets the service provider.
And Section 86 holds the product seller liable. The texts specify that a seller is not shielded simply because they are a middleman.
This is crucial. They are liable if they exercise substantial control over the product, or if the identity of the manufacturer is not known, or if the manufacturer is not subject to the law in force in India.
That last clause is a masterstroke against international dropshipping loopholes. A domestic e-commerce platform cannot import unregulated electronics from an overseas factory, sell them at a markup, and then when the product causes a fire, say, sue the factory in another country.
The 2019 Act dictates that if you profit from introducing the product into the Indian market, you, the seller, absorb the product liability.
And the punitive consequences are staggering. The Act outlines severe punishments for the manufacture or sale of spurious goods that result in injury, up to 7 years in prison and a 5 lakh rupee fine.
And if the catastrophic failure of the product results in the ultimate harm death, the term of imprisonment is heavily escalated, a minimum of 7 years, extending to life imprisonment and massive fines.
Life imprisonment. That is a monumental shift from the patchwork era. That is the state declaring, if you inject lethal products into the stream of commerce, we will permanently revoke your physical freedom.
It is an incredibly heavy shield. However, a functional market requires predictability for businesses as well. The law codifies specific exceptions to product liability.
Like if the manufacturer can prove the product was misused or altered by the consumer, right?
Yes. Furthermore, the legal system relies on the integrity of the claims presented. The forms must be protected against frivolous litigation. The sources highlight the Sapient Corporation Employees versus HDFC Bank Ltd case from 2012 to illustrate this.
Let's analyze that. The complainant filed an action against HDFC Bank, alleging that debited funds constituted a gross deficiency in service. On the surface, a David versus Goliath scenario.
But when the court examined the transaction, they discovered HDFC Bank had executed the debit in strict conformity with the binding directions issued by the overarching financial regulatory authority.
The bank was legally compelled to act exactly as it did. So how did the court rule?
They dismissed the complainant's arguments. Their reasoning is foundational. A behavior that conforms to the direction of a regulatory authority cannot be said to be negligence or service deficiency.
That ruling is the bedrock of a rational legal system. The law provides an impenetrable shield against corporate exploitation, but it demands genuine grievances. The shield protects the buyer, but it does not grant the buyer a license to harass a compliant entity.
Every baseless lawsuit clogs the docket of the commissions, delaying justice for consumers who have suffered legitimate harm.
Having profound rights on a digital piece of paper is meaningless without a mechanism to enforce them. Consider a scenario. I am watching television, and I see a deeply manipulative advertisement for a pediatric supplement that makes fraudulent scientific claims. I haven't bought it yet. Under the old system, do I just wait for thousands of parents to be defrauded before the commissions can act?
This raises an important question about the fundamental flaw of a purely reactive judicial system. Prior to 2019, someone had to absorb the economic damage and file a complaint. The system reacted to the bleeding. The 2019 Act revolutionized this by creating the Central Consumer Protection Authority, or the CCPA.
Section 10 establishes the CCPA, and it doesn't sound like a traditional court.
It's an investigative and proactive body. Its mandate is to regulate matters relating to the violation of consumer rights, unfair trade practices, and false or misleading advertisements.
How does it differ from a court?
The CCPA doesn't wait for individual lawsuits. It represents consumers as a macroscopic class. It has an investigation wing. It can act suo motu on its own motion.
So they can investigate unilaterally and force companies to reimburse consumers before a consumer even has to sue.
Exactly. They can order immediate recalls of dangerous goods. And regarding your fraudulent pediatric ad scenario, under Section 21, the CCPA can issue binding directions to immediately discontinue the false advertisement.
And punish false advertisers.
Yeah.
But the most fascinating innovation is the expansion of liability to the endorser.
Yes. This changes the entire dynamic of celebrity marketing. Historically, a famous actor could swear by a fraudulent health product, and when the scam collapsed, they'd claim ignorance. The CCPA eradicates that shield.
It demands accountability from influence. The CCPA can legally prohibit the endorser from participating in the endorsement of any product for up to a year, or 3 years for subsequent violations.
By threatening the personal brand of the celebrity, the CCPA essentially deputizes their legal team to audit the product. The CCPA acts as a watchdog, attempting to neutralize Goliath before David ever has to step onto the battlefield.
It is an incredibly robust preventative layer. But when disputes inevitably occur, the 2019 Act retains the reactive three-tier quasi-judicial machinery. Let's outline this for the listener. The foundational level is the District Commission.
Established by state governments in every district, this is where the overwhelming majority of everyday commercial disputes are adjudicated.
If the consumer is dissatisfied, or the claim value is higher, they escalate to the State Commission,
which operates with dual functionality: appellate jurisdiction over district commissions and original jurisdiction for higher financial stakes.
and the apex is the National Commission.
Headquartered in the NCR, established by the central government. It adjudicates appeals from state commissions, handles the highest value complaints, and wields revisional jurisdiction over all lower commissions.
And appeals flow all the way up to the Supreme Court, ensuring consumer rights are tethered to the highest constitutional authority. So we have summarized all this amazing protection, but wait, we have to do our part too, right?
Yes, this is a vital counterbalance. The law does not view the consumer merely as a fragile entity to be endlessly coddled. Commerce is a two-way street, a shared ecosystem. The sources explicitly detail the responsibilities of the consumer.
What exactly is our required contribution? The foundational responsibility is the mandate to be quality conscious, looking for standard quality certification marks like the ISI mark, AG mark, or FPO.
The government has built the lighthouse. The consumer has a fundamental responsibility to open their eyes and look at the beam.
What is the next responsibility?
The responsibility to proactively ignore misleading advertisements. The law expects the consumer to exercise a baseline of critical thinking. Do not base purchasing decisions solely on exaggerated claims in a commercial.
You have to inspect goods before buying. Rational choice is expected. And moving to the practical, the sources emphasize asking for cash memos.
This is the linchpin. The text explicitly states you must have evidence of purchase to file a complaint. Demanding a receipt hands you the key to the courthouse doors.
And the proper use of the product. The texts note a trend where individuals recklessly abuse a product during warranty, assuming it will be replaced for free. If you intentionally abuse a machine, the massive shield of product liability is instantly withdrawn.
The entire architecture is engineered to rectify genuine corporate failures, not to subsidize consumer sabotage or fictitious complaints. The forums can actually penalize the consumer for those.
There is one final responsibility articulated in the sources: the ethical responsibility to the ecology. Consumers should not waste natural resources and energy or cause environmental pollution.
True consumer empowerment includes the moral responsibility to consume sustainably.
So what does this all mean? We initiated this deep dive trapped in a visceral moment of powerlessness, staring at a bag of adulterated spices or a mechanic holding our keys hostage. In those moments, we felt small.
But the reality is you are flanked by decades of intense legal evolution.
We traced the long arc, from the vulnerable buyer of the patchwork era to the global recognition by the UN in 1985. We analyzed how the 1986 Act granted us the 6 rights and compensatory redress.
And we explored how the 2019 Act acts as a highly advanced GPS system for the digital age, holding global supply chains liable and unleashing the CCPA.
The Osmani University Law professor's syllabus isn't just theory, it's the rulebook for daily life. It acts as a personal legal shield. But this immense machinery sits completely idle unless you, the individual, choose to engage its gears. You must demand the receipt, look for quality marks, and refuse to stay silent when exploited. The architecture has paved the pathway to justice, but you have to be willing to take the first step.
It is a deeply empowering realization. But as we close, it leaves us looking out toward an accelerating horizon. The 2019 Act beautifully adapted to e-commerce and digital marketplaces, but as artificial intelligence begins to actively curate what we buy, make purchasing decisions for us, or even generate the products we consume, who will the law hold responsible when the algorithm gets it wrong? Are we ready for the next evolution of consumer protection?